any less appalling. We cannot stand idly by and allow such painful terminations of human life to continue. I urge passage of this bill, and I look forward to casting my vote in support of the rule, and I yield back my time.
Gentleman yields back. Gentlelady from New York.
Somebody just dropped off. Mr. Speaker, I am pleased to yield 2 minutes to the gentlelady from Hawaii, Ms. Hanabusa.
Gentlelady from Hawaii, recognized for 2 minutes.
Thank you, Madam Speaker. Madam Speaker, I rise in strong opposition to this rule. I stand here on behalf of the women in Hawaii and across the nation that we must continue to protect the fundamental right of women to have access to safe and legal abortion care. I strongly oppose the underlying bill, H.R. 1797, and encourage my colleagues to do the same. The bill is like a leap backwards for women in our nation. The very premise of this bill is contrary to credible scientific evidence and does not have the widespread support of our leading experts. H.R. 1797 goes against a decades-old Supreme Court ruling, Roe v. Wade, that gave women a fundamental right to choose, a protection provided in the United States Constitution. And remember, states were given the ability to regulate those laws. These proposed federal restrictions are unconstitutional, inappropriate, and unnecessary. Abortion is one of the safest medical procedures available in this country due to large part to the expertise and skill of our nation's trained medical professionals who offer high-quality care to women. This bill would threaten our doctors with 5-year prison terms for doing their jobs, even those that are caring for women who are facing serious health concerns and their pregnancies. It is critically important that our laws protect and support the woman's health, not deny access to care. Abortion care is a private medical decision between a woman and her health care provider. It is not the responsibility of Congress to infringe upon that right. That is why the American Congress of OBGYNs, American Nurses Associations, and 46 other organizations, in addition to 15 religious groups, stand in strong opposition to this bill. For these reasons, I urge my colleagues to stand strongly in opposition to this harmful and misleading bill and soundly vote no on the rule. I yield back.
Gentlelady's time's expired. The gentlelady from North Carolina.
Thank you, Madam Speaker. There's a lot of talk about rights here today. Very little talk about the right to life for the babies that are being aborted. Madam Speaker, I now yield 2 minutes to the gentleman from Michigan, Mr. Beneček.
Gentleman from Michigan is recognized for 2 minutes.
Thank you, Madam Speaker. I'd like to thank the gentleman from North Carolina for allowing me to be here as well. I rise today in support of the rule for H.R. 1797, the Pain-Capable Unborn Child Protection Act, and to urge my colleagues to support this important and long overdue piece of legislation. This bill will help to protect those in our society who are least able to defend themselves, the unborn. The Pain-Capable Act will prohibit late-term abortions after the 20th week of a pregnancy, for the simple reason that by 20 weeks of development, unborn children are able to feel and react to pain. This time period is based on extensive scientific research, and the majority of the American people are in favor of banning late-term abortions when they know that the unborn child is able to feel pain. As a doctor, I was horrified to hear the stories of gross misconduct and negligence that came to light in the trial of the Philadelphia abortionist Kermit Gosnell. The callous disregard for innocent human life that was displayed in the Gosnell Clinic extended beyond unborn children to adult patients. And I believe that there is bipartisan agreement that this was terrible. The Pain-Capable Act will help to prevent some of the worst abuses that were perpetrated by Kermit Gosnell and protect patients nationwide. As the overwhelming majority of my constituents in northern Michigan believe, life inside the womb is just as precious as life outside the womb, and it must be protected. I urge my colleagues to support this rule and the underlying legislation. And I yield back the balance of my time.
Gentleman yields back his time. The gentlelady from New York.
Madam Speaker, I am pleased to yield 2 minutes to the gentlewoman from Wisconsin, Ms. Moore.
Gentlelady from Wisconsin for 2 minutes.
Well, thank you so much, Ranking Member and Madam Speaker. I rise today to voice my strong opposition to H.R. 1797, which would callously and cavalierly limit access to abortion for women across the country. Well, I tell you, the House GOP has truly pushed the limits this time by offering this unconstitutional bill. Madam Speaker, this week, the much-maligned Miss USA contestant, Miss Utah, alluding to the power dynamics between men and women in the workplace, was lampooned for a flubbed answer when she said, and I quote, "I think especially the men are seen as the leaders of this, and so we need to try to figure out how to create education better so that we can solve this problem." Unquote. However inarticulate, I think Miss Utah was on to something. When you consider the subject at hand, women's right to a medically safe abortion, we once again see men taking leadership roles in invading the privacy and medical decisions of women, so that now we have before us a bill that is born of ignorance and disregard for medical science in every way, shape, and form. No concern for the biology, physiology, sociology of the woman. Perhaps if we could create education better of the importance of women's lives, we would not be here with this bill before us. This bill is an abomination, plain and simple. At its foundation, at its heart, is utter disrespect for the dignity and health of women. It also has other harmful effects. Now, I am sympathetic for those women as well who face an abortion at 20 weeks. Often these women are facing complications that endanger their health, or they have found out about a severe fetal anomaly. Others are victims of rape or incest. These are the most difficult decisions in their lives.
May I yield the gentlelady an extra minute?
Thank you, Madam.
Gentlelady is recognized for an additional minute.
Thank you, Madam Speaker. Medical providers have told us of harrowing tales of women who develop life-threatening preeclampsia with impaired kidney function, seizures, dangerously high blood pressure that threatens their health. They also tell us of the women who receive an aggressive cancer diagnosis right in the middle of their pregnancy and have to make the difficult choice between their pregnancy and their own life. In situations like these, women need to be able to consult their families and their doctors and no one else. Perhaps their own priest or rabbi or imam, but most certainly not their politician. Denying women the care they need is hazardous, cruel, and is simply the wrong thing to do. And I thank the lady for yielding time, and I yield back.
Gentlelady yields back her time. Gentlelady from North Carolina.
Thank you, Madam Speaker. This bill is not born of ignorance, but of extremely deep-felt concern for unborn children who suffer pain as they are being murdered. Madam Speaker, I fear for the conscience of our nation because the termination of unborn children, for any reason, is tolerated in some parts of our country throughout pregnancy, even though scientific conclusions show infants feel pain by at least 20 weeks gestation. That means literally that a baby at the halfway point of a pregnancy will experience pain during the violence of a dismemberment abortion, the most common second trimester abortion, wherein a steel tool severs limbs from the infant and its skull is crashed. Madam Speaker, it's even difficult for me to describe this procedure without getting emotional. These procedures are horrific, and in terms of pain, like torture to their infant subjects. As a country, we should leave this practice behind. That is why I'm a co-sponsor of the underlying legislation to prohibit elective abortions in the United States past 20 weeks. Since 1973, approximately 52 million, Madam Speaker, children's lives have been tragically aborted in the United States. It is unconscionable that in America, where we fight for life, liberty, and the pursuit of happiness, we tolerate the systemic extermination of an entire generation of the most vulnerable among us. H.R. 1797 rejects that hypocrisy and provides common-sense protections for unborn children who feel pain just as you and I do. My colleague and friend from Arizona, Representative Trent Franks, is a champion for the unborn, and I commend him for authoring this legislation, which prohibits an abortion of an unborn child that has surpassed 20 weeks after fertilization. In light of the recent conviction of Philadelphia-based late-term abortionist Kermit Gosnell, who was found guilty of first-degree murder in the case of 3 babies born alive in his clinic and then killed through a procedure he called snipping, which involved Gosnell inserting a pair of scissors into the baby's neck and cutting its spinal cord, a procedure that was reportedly routine in his clinic. We cannot stand idly by. Madam Speaker, some would have us think that Gosnell is an anomaly or an outlier. However, after his conviction, more individuals have stepped forward to expose similar practices in other states. Americans should be asking, how different are these snipping procedures from abortions performed throughout clinics in the country? Unfortunately, there's little difference between these procedures. The practice of murdering viable unborn children who can feel pain must end. I urge my colleagues to join me in speaking for those who cannot speak for themselves and vote in favor of this rule and the underlying bill, and I reserve the balance of my time.
Gentlelady reserves. The gentlelady from New York.
Madam Speaker, I am pleased to yield 2 minutes to the gentleman from Illinois, Mr. Snyder.
Gentleman from Illinois for 2 minutes.
Thank you, Madam Speaker. I rise today in strong opposition to the rule and the underlying bill, H.R. 1797. When debating the issue before us, it is important to understand that this is not strictly a matter of conscience, but an issue with very real and potentially life-altering implications for women and families across the nation. It is my fundamental belief that the right to choose is and must remain a personal health decision that a woman makes in consultation with her doctor without government intervention. Additionally, we should also be promoting policies that strive to reduce the number of unwanted pregnancies through improved access to family planning and contraception, as well as effective sex education. Sadly, rather than coming together to address our fiscal challenges and help stimulate job creation, the majority continues to doggedly pursue a radical ideological agenda. This legislation, like other attempts to restrict women's access to comprehensive health care, is unacceptable and could seriously endanger the health and safety of women across the country. As such, I firmly oppose the underlying bill and urge all of my colleagues to do the same. I yield back the balance of my time.
Gentleman yields back. The gentlelady from North Carolina.
Madam Speaker, I now yield three minutes, 5 minutes to the distinguished gentleman from New Jersey, Mr. Smith.
The gentleman from New Jersey is recognized for 5 minutes.
I thank the chair, and I want to thank my good friend and colleague for yielding. You know, Madam Speaker, pain, we all dread it, we avoid it, we even fear it, and we all go to extraordinary lengths to mitigate its severity and its duration. There are Kermit Gosnells, Madam Speaker, all over America, today inflicting not only violence, cruelty, and death on very young children, but excruciating pain as well. Many Americans, including some who self-identify as pro-choice, were shocked and dismayed by the Gosnell expose and trial. Perhaps the decades-long culture of denial and deceptive marketing has made it difficult to see and understand a disturbing reality. Even after 40 years of abortion on demand and over 55 million dead babies and millions of wounded moms, many until Gosnell somehow construed abortion as victimless and painless. That has changed. The brutality of severing the spines of defenseless babies, euphemistically called snipping by Gosnell, has finally peeled away the benign facade of a billion-dollar abortion industry. You know, I'd note parenthetically, it may come as a shock to many, but according to the Americans United for Life Legal Defense Fund, the U.S. is among only 4 nations in the world that allows for abortions for any reason after viability, and one of only 9 nations that allows abortions after 14 weeks. We're in some pretty bad company, Madam Speaker, because that includes China and North Korea. We are far outside the global mainstream. I would note, Madam Speaker, that like Gosnell, abortionists all over America decapitate, they dismember, and they chemically poison babies to death each and every day. That's what they do. Americans are connecting the dots and asking whether the Gosnell and what Gosnell did is really different than what other abortionists do. I would note to my colleagues that a D&E abortion, a common method after 14 weeks, is a gruesome, pain-filled act that literally rips and tears to pieces the body parts of a child. The Pain-Capable Unborn Child Protection Act is a modest but necessary attempt to at least protect babies who are 20 weeks old and pain-capable from having to suffer and die from abortion. I would note to my colleagues that a majority of Americans are with us, trying to protect lives. According to a recent Gallup poll, 64% of Americans believe that abortion should not be permitted in the second 3 months of pregnancy. 80% say abortion should not be permitted in the last 3 months of pregnancy. The polling company found that 63% of women believe that abortion should not be permitted at the point, after the point where substantial medical evidence says that the unborn child can feel pain. The women get it, and they have so polled when asked that they are against this kind of pain for babies. The Pain-Capable Unborn Child Protection Act recognizes the medical evidence that unborn children indeed feel pain. We're not living in the dark ages. One leading expert in the field of fetal pain, Dr. Anand at the University of Tennessee, stated in his expert report commissioned by the U.S. Department of Justice that, quote, "In my opinion, the human fetus possesses the ability to experience pain from 20 weeks of gestation, if not earlier, and the pain perceived by a fetus is possibly more intense than that perceived by term newborns and older children." Surgeons today entering the womb to perform corrective procedures, Madam Speaker, on unborn children have seen these babies flinch, jerk, recoil from sharp objects and incisions. Surgeons routinely administer anesthesia to unborn children in the womb. You know, we now know that the child ought to be treated as a patient, and there are many anomalies, many sicknesses that can be treated while the child is still in utero. When those interventions are done, anesthesia is given. Dr. Colleen Malloy, Assistant Professor, Division of Neonatology at the Northwestern University, in her testimony before the House Judiciary Committee in May of 2012 said, "When we speak of infants at 20 weeks post-fertilization, we no longer have to rely on inferences or ultrasound imagery, because such premature patients are kicking, moving, and reacting and developing right before our eyes in the neonatal intensive care unit." In other words, there are children the same age who in utero can be killed by abortion who have been born and are now being given life-saving assistance. She went on to say, in today's medical arena, we resuscitate patients at this age and are able to witness their ex utero growth. She says, "I could never imagine subjecting my tiny patients to horrific procedures such as those that involve limb detachment or cardiac injection." I thank my friend.
Gentleman's time's expired. The gentlelady from New York.
Madam Speaker, I'm pleased to yield 2 minutes to the gentlewoman from California, Ms. Davis.
Gentlelady from California, recognized for 2 minutes.
Thank you. Thank you, Madam Speaker. I join my many colleagues today who have spoken out against this outrageous bill. And I also want to object to the way that my colleagues on the other side of the aisle have brought up H.R. 1797 for consideration. When a bill that affects the lives and the health of women all across our country is coming up for this consideration, we deserve to have an open process. But instead, the majority is taking a rather undemocratic approach, blocking all amendments to this harmful bill. Beyond the fact that the bill is unconstitutional, it endangers the lives of women across our country. It places a ban on abortions with the narrowest of rape and incest exceptions, and it forces a woman who has been raped to report the attack to law enforcement before seeking an abortion. So I have to ask these questions. Do the sponsors of this legislation understand the trauma that a rape survivor endures? And do they understand what a cruel message that is to send to a woman in her time of greatest need? You know, Madam Speaker, those of us who are here in the Congress, I believe we all came here to solve the problems of the day as we address our national priorities. Is this issue high on their list? Is this the issue that gives people confidence that Congress understands the challenges that people throughout America face today? I know what those challenges are, I think. I've listened to my constituents. They worry about putting food on the table, a roof over their heads, and sending their kids to college. So here we are with a very narrow agenda, with an issue that is being used to strike at the heart of women's health issues. I urge my colleagues, please reject this bill, this rule, and the underlying bill. Thank you.
Gentlelady's time's expired. The gentlelady from North Carolina.
Thank you, Madam Speaker. Even Kermit Gosnell's own defense attorney, having gone through all the evidence at trial, said, quote, "I've come out of this case realizing that 24 weeks is a bad determiner. It should be more like 16, 17 weeks. That would be a far better thing, and I think the law should be changed to that. I think pro-choice would have still the right to choose, but they've got to choose quicker." We are talking here, Madam Speaker, about the beginning of the 6th month of pregnancy. Nothing in this bill has any impact on abortion during the first 20 weeks. And with that, I reserve the balance of my time.
Gentlelady reserves. The gentlelady from New York.
Madam Speaker, may I inquire if my colleague has other requests for time?
Madam Speaker, we will use the balance of our time.
Oh, well, that sort of leaves me uninformed. But I want to introduce the previous question before I do my closing, and I'm hoping you are prepared to close. Is that correct?
No, Madam Speaker, I'm not just yet ready to close.
All right.
But if my colleague is ready to close.
No, I'll reserve the balance of my time.
Gentlelady from New York reserves her time. The gentlelady from North Carolina.
Is the gentlewoman from New York ready to close? I thought that was the question she was asking.
That was a question I'd ask you. I am prepared to. Mr. Connolly is my last speaker.
The gentlelady from New York like to recognize the gentleman?
Not until I find out if this is going to be, if we're prepared to close.
Madam Speaker, I would recognize myself for such time as I may consume.
Gentlelady from North Carolina recognized.
Madam Speaker, As advances in medical science result in improved treatments and personalized medicine, the development of unborn children is further understood. Doctors can perform life-saving surgeries on babies still in the womb at earlier points in the pregnancy than ever before. When a baby is born prematurely, medical innovation is increasing the likelihood of that baby's survival. Babies born as early as 20 weeks post-fertilization are being cared for in neonatal units across the country. By 8 weeks after fertilization, the unborn child reacts to touch. By 20 weeks post-fertilization, the unborn child reacts to stimuli that would be recognized as painful if applied to an adult human. The baby responds the same way you and I respond to pain, by recoiling from it. As Dr. Anand at the University of Tennessee is considered the leading expert in the field of fetal pain and stated in a report accepted by a federal judge as expert testimony that, quote, "It is my opinion that the human fetus possesses the ability to experience pain from 20 weeks of gestation, if not earlier, and the pain perceived by a fetus is possibly more intense than that perceived by term newborns or older children," end quote. Surgeons entering the womb to perform corrective procedures on unborn children have seen those babies flinch, jerk, and recoil from sharp objects and incisions. Recognizing this discomfort, surgeons routinely administer anesthesia to unborn children in the womb before performing surgeries. According to Planned Parenthood, the largest abortion provider in America, babies aborted at 14 weeks or later are often subjected to a painful dismemberment abortion, which involves inserting a long steel tool into the womb and grabbing usually an arm or a leg, tearing it from the baby's body and pulling it out of the mother. The procedure is repeated as the baby is torn limb from limb until his or her entire body has been removed and the head is finally crushed and removed. The dismemberment abortion is the most common method of abortion in the second trimester. Another abortion procedure involves injecting Dioxin and or potassium chloride into the baby's heart, which induces cardiac arrest and the baby's kill. Madam Speaker, it's important that the American people understand exactly what happens when they hear the word abortion. It is a heart-wrenching, painful procedure that tears a baby limb from limb before crushing his or her head, or it is a poisonous chemical injection. A March 2013 poll conducted by the polling company found that 64% of the public supports a law like the Pain-Capable Unborn Child Protection Act prohibiting an abortion after 20 weeks when an unborn baby can feel pain unless the life of the mother is in danger. Supporters included 47% of those who identified themselves as pro-choice in the poll. The poll also found that 63% of women believe that abortion should not be permitted after the point where substantial medical evidence says that the unborn child can feel pain. Madam Speaker, Congress cannot sit idly by while this grotesque and brutal procedure, which rips the tiny baby apart limb by limb in the womb, is performed in our country. That is why it is necessary for Congress to pass H.R. 1797 and protect the lives of these unborn children from this excruciating pain. And Madam Speaker, I ask unanimous consent to submit for the record a summary of the evidence of the unborn pain research. Madam Speaker, I now reserve the balance of my time.
Gentlelady from North Carolina reserves her time. The gentlelady from New York.
May I have this 30 seconds on my own? I just think Congress should not be standing around while this is going on. Congress should also not be standing around while college loan rates are doubling and we have so many people out of work. I'm delighted to yield 2 minutes to my friend from New York, the gentlewoman, Carolyn Maloney.
Gentlelady from New York, recognized for 2 minutes.
I thank my fellow New Yorker and good friend for yielding and for her outstanding leadership in this body on so many many issues, particularly in the area of health. My colleagues, once again, we need to ask ourselves, where were the women when the Judiciary Committee produced this outrageous assault on women's health and women's reproductive rights? The answer is very clear on this panel. There is not one female face participating in this crucial issue in their health care. Absolutely nowhere. This is a photo of the members of the Judiciary Subcommittee that held a hearing on this legislation before us, and not one Republican on that panel is a woman. And the bill that was produced is evidence that women did not participate in this decision-making. For example, it was not until the chair of that subcommittee made a comment not worthy of this House that the majority added an insulting and narrow exception for pregnancies resulting from rape. Last November, women came out in droves to say, keep your laws off our bodies, out of our personal lives, and out from between women and their doctor. This bill that a man sponsored, that an all-male panel has approved, jeopardizes the health and well-being of women and only women. It is indifferent to the rights of women and only women, and it is callous to the concerns of women and only women. And I can promise you that women will long remember this. They will remember it today, they will remember it tomorrow, and they will remember it at the polls when they select their representatives. I yield back to my distinguished colleague my remaining time.
Gentlelady's time has expired. The gentlelady from North Carolina.
I continue to reserve, Madam Speaker.
Continues to reserve. The gentlelady from New York.
Madam Speaker, if we can defeat the previous question, I will offer an amendment to the rule that would allow the House to hold a vote on the Student Loan Relief Act. If Congress doesn't act next month, the undergraduate students across this country will see a doubling of their student loan interest rates. And to discuss our proposal, I am pleased to yield 2 minutes to the gentleman from Connecticut, Mr. Courtney.
Gentleman from Connecticut for 2 minutes.
Thank you, Madam Speaker. Madam Speaker, I rise to oppose the previous question so that the House can take up the Student Loan Relief Act, H.R. 1595, which is a bill that the American people are truly concerned about and watching Congress to see whether or not we do the right thing. In 12 days, as this chart shows, the subsidized Stafford student loan rate will double from 3.4% to 6.8%. This will add to the debt burden of the average college student with a Stafford student loan portfolio of about approximately $5,000. Today, the average student is leaving college with an average debt level of about $25,000 to $26,000. We know the big numbers. $1.1 trillion in student loan debt now in the U.S. economy, more than credit cards, more than used cars. And yet, we are standing here 12 days before the doubling of this rate. We are debating a bill which is right in the middle of the polarized gridlock politics that the American voters rejected soundly in the last election, rather than dealing with the bread and butter issues that really matter to young Americans and to middle-class families all across this country. The fact of the matter is, we know young people in this country need to get a post-high school degree, whether it's a 2-year degree or a 4-year degree. The Stafford Student Loan Program is the workhorse of providing affordable loans for millions of students. 7.5 million students use the Stafford subsidized student loan program. Yet if we don't act in 12 days, that 7.5 million are going to see their interest rates double to 6.8%. Now, we may hear from the other side, well, we took up a bill on May 23rd, H.R. 1911, a bill with a variable rate that we now know from the Congressional Budget Office, who issued a report this past Monday, will be, in fact, worse than if we did nothing and allow the rate to go to 6.8%. That's been not only verified by the Congressional Budget Office, but also by the Education Trust and Institute for College Access and Success, a nonpartisan group funded by the Bill and Melinda Gates Foundation, the Walton Family Trust, and it states very clearly, if passed, it will lead to higher rates on all types of federal student and parent loans than if Congress did nothing at all. We need to act on H.R. 1595. 187 members have signed a discharge petition.
And the gentleman's
it is time to act and protect American college students. I yield back the balance of my time.
The gentlelady from North Carolina.
Thank you, Madam Speaker. As our colleagues on the other side of the aisle know full well, and as our colleague from Connecticut has acknowledged, the House has passed a bill to take care of the issue of student loan rates doubling on July 1st. However, the Senate has refused to act on the bill. What we passed was what the President asked for in his budget, and he has suddenly flip-flopped on the issue and doesn't support it anymore. The House has done its job. We're now waiting for the Senate and the President to acknowledge that they have a responsibility in this area. We've not been frivolous about this. We are not ignoring the issue. And with that, I reserve the balance of my time.
Gentlelady from North Carolina reserves her time. The gentlelady from New York.
Thank you, Madam Speaker. On July 1st, young women in college face a doubling of federal student interest loan rates. But instead of legislating the rights of our daughters and granddaughters to access safe and legal reproductive care, we should be ensuring that the cost of college doesn't skyrocket at the end of the month. And when it comes to the most personal and important decisions a woman will ever make, we deserve the privacy and freedom to make the decision that's right for us. No matter how many women the majority trots out to advance their agenda, their attempts to take away our reproductive rights will not stand. Madam Speaker, I ask unanimous consent to insert with the text of the amendment in the record along with extraneous material immediately prior to the vote on the previous question.
Without objection.
I urge my colleagues to vote no to defeat the previous question and urge a no vote on the rule and yield back the balance of my time.
Gentlelady from New York yields back the balance of her time. The gentlelady from North Carolina.
Thank you, Madam Speaker. I would like to point out that none of the members on the other side of the aisle have even acknowledged the pain that unborn children feel, or the fact that half of those babies that are being murdered are little girls. Madam Speaker, life is the most fundamental of all rights. It's sacred and God-given. But millions of babies have been robbed of that right in this, the freest country in the world. This is a tragedy beyond words and a betrayal of what we as a nation stand for. Before liberty, equality, free speech, freedom of conscience, the pursuit of happiness, and justice for all, there has to be life. And yet, for millions of aborted infants, many pain-capable and many discriminated against because of gender or disability, life is exactly what they've been denied. And an affront to life for some is an affront to life for every one of us. One day, we hope it will be different. We hope life will cease to be valued on a sliding scale. We hope the era of elective abortions ushered in by an unelected court will be closed and collectively deemed one of the darkest chapters in American history. But until that day, it remains a solemn duty to stand up for life. Regardless of the length of this journey, we will continue to speak for those who cannot. And we will continue to pray to the one who can change the hearts of those in desperation and those in power who equally hold the lives of the innocent in their hands. May we, in love, defend the unborn. May we, in humility, confront this national sin. And may we mourn what abortion reveals about the conscience of our nation. Madam Speaker, we go to extraordinary lengths to save not only human beings but even animals because we value life so much. However, there are many who do not hold the unborn in the same esteem, and that is tragic. For more than 1 million unborn babies every year, There's nothing more important than protecting voiceless, unborn children and their families from the travesty of abortion. Therefore, I urge my colleagues to vote for life by voting in favor of this rule and the underlying bill. I yield back the balance of my time, and I move the previous question on the resolution.
Gentlelady yields back the balance of her time. And the question is on ordering the previous question on the resolution. And those in favor will signify by saying aye. Aye. Those opposed will say no. In the opinion of the chair, the ayes have it, the ayes have it.
Madam Speaker,
Gentlelady from New York.
I request the yeas and nays.
The yeas and nays are requested, and those favoring a vote by the yeas and nays will rise. A sufficient number having arisen, the yeas and nays are ordered. Members will record their votes by electronic device. And pursuant to Clause 8 and Clause 9 of Rule 20, this 15-minute vote on ordering the previous question will be followed by 5-minute votes on adoption of House Resolution 266, if ordered, and the motion to suspend the rules on H.R. 1151. This will be a 15-minute vote, a 15-minute vote.
The House for the past hour has had under consideration the rules for debate of a bill that would ban abortions after the 20th week of pregnancy. It would make exceptions for instances of rape, incest, or if the abortion is necessary to save the life of the pregnant woman. It's a 15-minute vote. The rule also provides for consideration of a bill that will have a much longer debate, that is the 5-year Farm Bill. So a dual rule here for both bills. 15-minute vote here on the previous question. The rule vote is coming up next. The previous question, Ms. Slaughter, Representative Slaughter of New York, calling on Democrats to vote no on the previous question so that they can bring forth an amendment to the rule which would allow for consideration of Joe Courtney's bill on the student loan situation. During this 15-minute vote, we're going to first give you a look at the debate ahead on the underlying abortion bill from a reporter who's been covering the issue.
Rovner is the health policy correspondent for NPR. Why are House Republicans taking up a bill to ban abortions after 20 weeks of pregnancy?
Well, the committee reported it last week. We're frankly not quite sure why they're taking it up on such a quick action. When this bill was introduced just a couple of weeks ago, they weren't sure it was going to come up on the floor at all. It was definitely going to be marked up in the subcommittee, and then it got marked up in the full committee. But why they're bringing it to the floor with such alacrity is still a question that nobody is quite sure the answer to.
Now, there's been a change to the bill since it was marked up and approved in the Judiciary Committee last week. What is that change, and why was this language added?
That's right. Leaders announced last Friday, which was the day after the bill was marked up, that they would be adding an exception in the bill for rape and incest. Originally, as the bill came out of committee, this was going to be a ban on virtually all abortions after 20 weeks of pregnancy, with the exception of pregnancies that threatened the life of the woman. Now they're adding language for abortions in the case of rape and incest, and that was because there was a little bit of a dust-up at the markup. Trent Franks of Arizona, the sponsor actually of the bill, said that he said that abortions in the case of rape were rare. Now, he explained as the markup went on that what he meant was that abortions after 20 weeks resulting from rapes were rare. But Democrats took that language and really ran with it and made quite the fuss about it. And so they decided that they would add that language to the bill, even though an amendment failed actually at the markup. They've also decided not to let Congressman Franks manage the bill on the floor. Instead, it's going to be managed by Marsha Blackburn of Tennessee, which is interesting because she's not even a member of the Judiciary Committee, which is the bill that which is the committee that the bill emerged from.
Why do you suppose that's happening?
Well, I think that the Republicans are very sensitive. Obviously, you know, last year, Todd Akin, who was running for Senate from Missouri, also made comments about the unlikelihood of getting pregnant after a rape. He ended up losing his race, even though he was a prohibitive favorite at the time. So Republicans are very sensitive to this sort of thing, and I think when Congressman Franks made that comment, even though it's been taken a little bit out of context, I think they were very sensitive to that. And I wondered, you know, why Marsha Blackburn would be managing this bill when she's not even on the committee. Went back and looked down and realized there is not a female Republican on the Judiciary Committee, so they didn't have a woman to manage the bill. They had to actually turn to someone else in order to get a woman Republican to manage the bill.
So this is a Republican-sponsored sponsored bill. What's been the reaction from Democrats to the measure?
Oh, well, Democrats hate it. They point out, among other things, that it is facially unconstitutional, which Republicans do acknowledge. I mean, the Supreme Court has been pretty clear on this, that abortions cannot be banned before fetal viability, which pretty much everybody on both sides agrees is around 23 weeks and later of pregnancy. And since this reaches back to 20 weeks, an appeals court just a few weeks ago struck down a similar Arizona law. But what they are hoping by pushing this bill forward, in addition to making political statement about how much, Americans don't like abortions later in pregnancy, but what they're saying is that they're hoping that if it should pass and get to the Supreme Court, obviously unlikely given the makeup of the Senate and the fact that the President is unlikely to sign it, but should it somehow get to the Supreme Court, they're hoping that perhaps the Supreme Court would use this law to change its mind about this. But as it stands now, this does violate current Supreme Court precedent on abortion.
Let's go back to the House Judiciary Committee markup last week. What was that debate like?
It was pretty testy. The House Judiciary Committee has been through this a lot. There was a similar bill last year that only applied to the District of Columbia. Now, a number of states have passed these kinds of laws, and the justification, they say, is that scientists have suggested that 20 weeks of pregnancy is when a fetus can begin to feel pain. That is a scientifically disputed theory, but that is the justification under which these laws are being passed. The Judiciary Committee had a bill that would apply this only to the District of Columbia because they can, because Congress oversees laws in the District of Columbia. The House actually put it on the floor, but they put it under suspension of the rules, which requires a 2/3 majority, and it didn't pass. It didn't get the supermajority it needed. This bill is not going to be that way. This bill is coming with the rule. It only needs a simple majority, so it's considered much more likely that this bill will pass. But Democrats were, at the markup, we went through sort of similar that we've seen sort of over the years at the Judiciary Committee, Republicans talking about, how horrible abortion is and how much the American public doesn't like it. Democrats talking about, thinking about the woman and how the Constitution and the Supreme Court currently guarantees women a right to choose, and talking about some of the difficult situations, particularly later in pregnancy when women, particularly in difficult medical situations, should have this right.
Well, the bill is coming up Tuesday, and as you've said, you think it will pass. Who are you watching most closely?
Well, this generally tends to be a fairly Republican-Democratic split, although there are a lot of Democrats, particularly from the South, but not exclusively, Democrats who vote anti-abortion. This obviously was a big issue when the Affordable Care Act came up. There were many, many Democrats who were worried about, abortion votes and wanting to, maintain an anti-abortion voting record. Many of them actually got voted out in 2010, so there aren't quite as many as there used to be. But it is largely a party line issue, but not exclusively a party line issue. There are considerably fewer Republicans who vote with abortion rights backers these days. That has become a much rarer sight. So I would look to see if there are any of those. But again, I'll be interested in this particular bill because it does, on its face, as I mentioned, violate current Supreme Court precedent. So it will be interesting to see how many Republicans are willing to go out, as I mentioned, sort of on a limb, if you will. This is stretching kind of the bounds of how far you can go on an abortion bill and still be considered, within the realms of, I think, what the public really supports.
So what's likely to happen in the Senate if this bill does pass the House?
It's hard to say. I don't think the Senate would take up the bill as it is, but I could see someone trying to attach this to some other bill and try to force a vote, perhaps try to force some of the Democrats, from some of these some of these Democrats who are in maybe tough races, to have to take a vote on this, to make this a difficult vote. I could definitely see that happening.
And very quickly, how about the Obama administration? What is their take?
I don't believe they've said yet as of now, but it would be hard to imagine the president supporting this bill or doing anything except promising to veto it.
Julie Rovner is the health policy correspondent for NPR. Thanks for your time.
Thank you.
And late yesterday, the White House did issue their veto threat, saying in part in their statement of administration policy 40 years ago, the Supreme Court affirmed a woman's constitutional right to privacy, including the right to choose. This bill is a direct challenge to Roe v. Wade and shows contempt for women's health and rights. Part of the statement from the White House issued late yesterday in a bill coming up under consideration today that would ban abortions after the 20th week of pregnancy. This is the previous question vote. Democrats' last chance to change the rule before they vote on the rule. They've been bringing up the issue in debate of the still unresolved situation regarding the student loan interest rates. 15-minute vote on the House floor, and 2 more votes will follow, including a vote on the rule. Also today on Capitol Hill, we covered earlier the House Intelligence Committee hearing from the NSA Director General Alexander about their data collection program. During that same hearing, Deputy Attorney General James Cole delivered a detailed accounting of the legal process and oversight behind the NSA phone record and data collection programs. We'll show you as much as we can of his comments while this vote continues.
Andrew said, and as the chairman and ranking member have said, all of us in the national security area are constantly trying to balance protecting public safety with protecting people's privacy and civil liberties in this government, and it's a constant job at balancing this. We think we've done this in these instances. There are statutes that are passed by Congress. This is not a program that's off the books, that's been hidden away. This is part of what government puts together and discusses. Statutes are passed. It is overseen by 3 branches of our government: the legislature, the judiciary, and the executive branch. The process of oversight occurs before, during, and after the processes that we're talking about today. And I want to talk a little bit about how that works, what the legal framework is, and what some of the protections are that are put into it. First of all, what we have seen published in the newspaper concerning 215, this is the business records provisions of the Patriot Act that also modify FISA. You've seen one order in the newspaper that's a couple of pages long that just says, under that order, we're allowed to acquire metadata, telephone records. That's one of 2 orders. It's the smallest of the 2 orders, and the other order, which has not been published, goes into, in great detail, what we can do with that metadata, how we can access it, how we can look through it, what we can do with it once we have looked through it, and what the conditions are that are placed on us to make sure that we protect privacy and civil liberties and at the same time protect public safety. Let me go through a few of the features of this. First of all, it's metadata. These are phone records. This is just like what you would get in your own phone bill. It is the number that was dialed from, the number that was dialed to, the date, and the length of time. That's all we get under 215. We do not get the identity of any of the parties to this phone call. We don't get any cell site or location information as to where any of these phones were located, and most importantly, and you're probably going to hear this about 100 times today, we don't get any content under this. We don't listen in on anybody's calls under this program at all. This is under, as I said, Section 215 of the Patriot Act. This has been debated and up for reauthorization and reauthorized twice by the United States Congress since its inception in 2006 and in 2011. Now, in order, the way it works is there is an application that is made by the FBI under the statute to the FISA court. We call it the FISC. They ask for and receive permission from the FISC under this to get records that are relevant to a national security investigation. And they must demonstrate to the FISC that it will be operated under the guidelines that are set forth by the Attorney General under Executive Order 12333. This is what covers intelligence gathering in the federal government. It is limited to tangible objects. Now, what does that mean? These are like records, like the metadata, the phone records I've been describing, but it is quite explicitly limited to things that you could get with a grand jury subpoena, those kinds of records. Now, it's important to know prosecutors issue grand jury subpoenas all the time and do not need any involvement of a court or anybody else, really, to do so. Under this program, we need to get permission from the court to issue this ahead of time. So there is court involvement with the issuance of these orders, which is different from a grand jury subpoena, but the type of records, just documents, business records, things like that, are limited to those same types of records that we could get through a grand jury subpoena. Now, the orders that we get last 90 days. So we have to re-up and renew these orders every 90 days in order to do this. Now, there are strict controls over what we can do under the order, and again, that's the bigger, thicker order that hasn't been published. There's restrictions on who can access it in this order. It is stored in repositories at NSA that can only be accessed by a limited number of people, and the people who are allowed to access it have to have special and rigorous training about the standards under which that they can access it. In order to access it, there needs to be a finding that there is reasonable suspicion that you can articulate, that you can put into words, that the person whose phone records you want to query is involved with some sort of terrorist organizations, and they are defined. It's not everyone. They're limited in the statute. So there has to be independent evidence, aside from these phone records, that the person you're targeting is involved with a terrorist organization. If that person is a United States person, a citizen, or a lawful permanent resident, you have to have something more than just their own speeches, their own readings, their own First Amendment type activity. You have to have additional evidence beyond that that indicates that there is reasonable, articulable suspicion that these people are associated with specific terrorist organizations. Now, one of the things to keep in mind is under the law, the Fourth Amendment does not apply to these records. There is a case quite a number of years ago by the Supreme Court that indicated that toll records, phone records like this that don't include any content are not covered by the Fourth Amendment because people don't have a reasonable expectation of privacy in who they called and when they called. That's something you show to the phone company. That's something you show to many, many people within the phone company on a regular basis. Once those records are accessed under this process and reasonable articulable suspicion is found, that's found by specially trained people. It is reviewed by their supervisors. It is documented in writing ahead of time so that somebody can take a look at it. Any of the accessing that is done in an auditable fashion. There is a trail of it. So both the decision and the facts that support the accessing in the query is documented. The amount that was done, what was done, all of that is documented and reviewed and audited on a fairly regular basis. There are also minimization procedures that are put into place so that any of the information that is acquired has to be minimized, it has to be limited, and its use is strictly limited, and all that is set out in the terms of the court order. And if any U.S. persons are involved, there are particular restrictions on how any information concerning a U.S. person can be used in this. Now, there is extensive oversight and compliance that is done with these records and with this process. Every now and then there may be a mistake. A wrong phone number is hit, or a person who shouldn't have been targeted gets targeted because there's a mistake in the phone record, something like that. Each of those compliance incidents, if and when they occur, have to be reported to the FISA court immediately. And let me tell you, the FISA court pushes back on this. They want to find out, why did this happen? What were the procedures and the mechanisms that allowed it to happen, and what have you done to fix it? So whenever we have a compliance incident, we report it to the court immediately, and we report it to Congress. We report it to the intelligence committees of both houses and the judiciary committees of both houses. We also provide the intelligence and judiciary committees with any significant interpretations that the court makes of the 215 statute. If they make a ruling that is significant or issue an order that is significant in its interpretation, We provide those, as well as the applications we made for those orders, to the Intelligence Committee and to the Judiciary Committee. And every 30 days, we are filing with the FISC, with the court, a report that describes how we implement this program. It includes a discussion of how we're applying the reasonable articulable suspicion standard. It talks about the number of approved queries that we made against this database, the number of instances that the query results in containing U.S. person information that was shared outside of NSA, and all of this goes to the court. At least once every 90 days, and sometimes more frequently, the Department of Justice, the Office of the Director of National Intelligence, and the NSA meet to assess NSA's compliance with all of these requirements that are contained in the court order. Separately, the Department of Justice meets with the Inspector General for the National Security Agency and assesses NSA's compliance on a regular basis. Finally, there is, by statute, reporting of certain information that goes to Congress in semi-annual reports that we make on top of the periodic reports we make if there's a compliance incident. And those include information about the data that was required and how we are performing under this statute. So once again, keeping in mind, all of this is done with 3 branches of government involved: oversight and initiation by the executive branch with review by multiple agencies, statutes that are passed by Congress, oversight by Congress, and then oversight by the court. Now, the 702 statute under the FISA Amendments Act is different. Under this, we do get content, but there's a big difference. You are only allowed under 702 to target for this purpose non-U.S. persons who are located outside of the United States. So if you have a U.S. permanent resident who's in Madrid, Spain, we can't target them under 702. Or if you have a non-U.S. person who's in Cleveland, Ohio, we cannot target them under 702. In order to target a person, they have to be neither a citizen nor a permanent U.S. resident, and they need to be outside of the United States while we're targeting them. Now, there's prohibitions in this statute. For example, you can't reverse target somebody. This is where you target somebody who's out of the United States, but really your goal is to capture conversations with somebody who is inside the United States. So you're trying to do indirectly what you couldn't do directly. That is explicitly prohibited by this statute. And if there is ever any indication that it's being done, because again, we report the use that we make of this statute to the court and to the Congress, that is seen. You also have to have a valid foreign intelligent purpose in order to do any of the targeting on this. So you have to make sure, as it was described, that it's being done for defined categories of weapons of mass destruction, foreign intelligence, things of that nature. These are all done pursuant to an application that is made by the Attorney General and the Director of National Intelligence to the FISC. The FISC gives a certificate that allows this targeting to be done for a year period. It then has to be renewed at the end of that year in order for it to be re-upped. Now, there is a requirement that, again, there is reporting. You cannot, under the terms of this statute, have and collect any information on conversations that are wholly within the United States. So you're targeting someone outside the United States. If they make a call to inside the United States, that can be collected. But it's only because the target of that call outside the United States initiated that call and went there. If the calls are wholly within the United States, we cannot collect them. If you're targeting a person who is outside of the United States and you find that they come into the United States, we have to stop the targeting right away. And if there's any lag and we find out that we collected information because we weren't aware that they were in the United States, we have to take that information, purge it from the systems, and not use it. Now, there's a great deal of minimization procedures that are involved here, particularly concerning any of the acquisition of information that deals or comes from U.S. persons. As I said, only targeting people outside the United States who are not U.S. persons. But if we do acquire any information that relates to a U.S. person, under limited criteria only can we keep it. If it has to do with foreign intelligence in that conversation or understanding foreign intelligence or evidence of a crime or a threat of serious bodily injury, we can respond to that. Other than that, we have to get rid of it, we have to purge it, and we can't use it. If we inadvertently acquire any of it without meaning to, again, once that's discovered, we have to get rid of it, we have to purge it. The targeting decisions that are done are, again, documented ahead of time, reviewed by a supervisor before they're ever allowed to take place in the beginning. The Department of Justice and the Office of the Director of National Intelligence conduct on-site reviews of each targeting that is done. They look at them to determine and go through the audit to determine that they were done properly. This is done at least every 60 days and many times done more frequently than that. In addition, if there's any compliance issue, it is immediately reported to the FISC. The FISC again pushes back, how did this happen? What are the procedures? What are the mechanisms you're using to fix this? What have you done to remedy it? If you acquired information you should have you gotten rid of it as you're required? And in addition, we're providing Congress with all of that information if we have compliance problems. We also report quarterly to the FISC concerning the compliance issues that have arisen during that quarter, on top of the immediate reports, and what we've done to fix it and remedy the ones that we reported. We also, to Congress under this program, the Department of Justice and the Office of the Director of National Intelligence provide a semi-annual report to the FISC and to Congress, assessing all of our compliance with the targeting and minimization procedures that are contained in the court order. We also provide a semi-annual report to the FISC and to Congress concerning the implementation of the program, what we've done and what we found. And we also provide to Congress documents that contain, again, how we're dealing with the minimization procedures, any significant legal interpretations that the FISC makes concerning these statutes, as well as the orders and the applications that would relate to that. And on top of all of this, annually, the Inspector General for NSA does an assessment which he provides to Congress that reports on compliance, the number of disseminations under this program that relate to U.S. persons, the number of targets that were reasonably believed at the time to be outside the United States who were later determined to be in the United States, and what that was done. So in short, there is, from before, during, and after, the involvement of all three branches of the United States government on a robust and fairly intimate way. I'd like to make one other observation, if I may, on this. We have tried to do this in as thorough, as protective, and as transparent a way as we possibly can, considering it is the gathering of intelligence information. Countries and allies of ours all over the world collect intelligence.
And the nays are 196. The previous question is ordered. The question is on the adoption of the resolution, and those in favor will signify by saying aye. Aye. Opposed say no. In the opinion of the chair, the ayes have it. The ayes have it. The gentlelady from New York.
Madam Speaker, I request